Welcome. Today we're speaking with Noah Klug, who is the principal of Klug Law Firm, an immigration law practice here in New York City. Noah, welcome.
Thank you, James. It's wonderful to be here.
Now, Noah, I'm not detecting an Australian accent there, so perhaps we could first let our listeners know your connection to Australia.
Sure. Sounds great. My wife of 15 years is an Aussie. She's actually from Perth. We got married and we were living in New York City, where I'm from, around these parts. And I was finishing up law school, and then I took a job with the federal government in one of their U.S. immigration agencies in the Washington, D.C. area. Basically, in short, she was itching to get back home to Australia. I had a great experience with the government, but I was ready to, make a move into the private sector. And, like I said, my wife, was, looking to get back home. And so it just fit. And that was back in 2008. And so we were in Sydney for a little over a year, and then Melbourne for around 5 years. But yeah, and then so we were there 2008 to 2014. And so during that time, as you can imagine, really built up, this kind of niche of helping, Aussies and Australian companies that are expanding to the US, with, applying for US visas and green cards and that type of thing.
Noah, they say there's three levels of koala file. An American who always wanted to go to Australia, but it's too far away. Someone who knows someone who went to Australia. And then there's the third level, there's an American who went to Australia and didn't want to come back. So I'm kind of figuring you're in that last category.
That's right. Yeah, absolutely. No, it was wonderful. It's just where life took us in terms of, coming back to the US, but I definitely miss it. And yeah, it's a wonderful place.
Perhaps, Noah, you could run down some of the things that you're seeing that would be of interest to our members who are on non-immigrant visas, such as O visas, L visas, and most importantly, the E3.
So, firstly, question that has been coming up a lot is, for Aussies that are here in E3 status and their status is expiring and they don't want to travel, travel is very hard right now. What can be done? And on that note, I find that there's oftentimes a lot of confusion about the immigration documents and different expiry dates, and that type of thing. So the first and usually most important one is the I-94. Okay, so this is not the visa. The visa is the sticker, the label that you get in your passport when after you're approved at the consulate. And the visa, I refer to it as like your entry ticket to the U.S. So if you're outside of the U.S., you need a valid visa to get in. But once you're in, it's irrelevant, completely irrelevant. What matters is the I-94. And the I-94, it used to be, a physical white card that the Customs and Border Protection officer would, write an expiry date on it and staple it in your passport. A couple of years ago, they went to a online system. And so now, and this also can sometimes, add to the confusion that you have to actually proactively check your I-94 online and ideally download it. So that's what defines your lawful status, for as an E3 visa holder or any non-immigrant visa holder in the U.S. It's the I-94. And so we often especially during these times, have had E3 clients coming to us say, oh, my E3 visa is expiring. I need to do something, but I can't travel. And then we go and we check their I-94 for them. And lo and behold, they've got another year, sometimes 2 years. And they're so happy, when we explain that to them because, travel, like I say, travel is, is hard right now with COVID. And oftentimes, folks want to be able to just stay put. And so in that scenario, usually all that needs to be done is renewing the labor condition application or LCA. So that's the first thing I would want to mention, about, E3 visa holders, issues that are coming up for them right now. And then secondly, we do have E3 visa holders who maybe their I-94 is expiring, or they need to do that international travel, and so they need to renew the visa. And then the question becomes where can they do that? And it's actually a pretty short answer, at least right now, in terms of where that can be done. And it's really Mexico. That's the big one right now for E3 visa holders who are currently in the U.S. and need to renew their visa or change employers, because of course there is an in-country change of employer process, but it takes forever, and so it's just not viable. So typically with the E3, if you need to change employers, you need to get that new visa, and Mexico has been the place. There are stories of folks being able to renew in other places here and there. I think Switzerland was mentioned, maybe some in Barbados, but the problem is, firstly, if you can actually even get into these other countries, countries are closing up in terms of COVID. And then secondly, even if you have to quarantine, and how long you have to quarantine. And then also, especially for Europe is a very common one, where if you go there, then you're subject to the travel ban that applies to Europe, UK, Ireland, China, Iran, and Brazil right now. So it really reduces the options, and yeah, like I say, I mean, right now it's a short answer in that Mexico is really the place where it's most viable, because you can get in pretty easily. They don't have the quarantine, requirements, at least as of now. The consulates are pretty friendly to E3 adjudication, which is great. Then the other option is Australia. It's a long way to go, and so usually it would only be, if the client is actually going home anyway, and then we try to tie it in. But sometimes, even if the client is planning a trip back home to Australia, they still want to do it in Mexico, just to have that peace of mind, of having the new visa and not having to worry about it, when they go back to Australia. And then in addition, things have been in quite a lot of flux in Australia in terms of visa appointment availability. We have had some clients that have been able to get appointments and have been able to renew, so it is possible. It's just really fluctuating a lot.
We've done some other interviews with flight experts, and the big concern is that so many people who are booking, say, economy tickets are getting bumped by business class tickets, because the airlines obviously want to fill business class because there's only a limited number of seats on the plane. So there has been a lot of challenges. So even if someone were to get an appointment in Australia, there could be, unless they're flying business, they could get bumped, and that creates a whole new set of complexities.
Right.
So yeah, the feedback we're getting as well is that Mexico seems to be relatively close, relatively inexpensive, especially for traveling with children for their renewals.
And, there's just some, kind of somewhat tricky aspects of it, that you have to get around. And that, I mean, if we're helping with the case, obviously we handle it all. But for example, the visa fees can only be paid in person at a bank in Mexico. So that can be challenging, because you need to pay the fees before you can make the appointment. So typically you want to make the appointment before you go to Mexico. But there are agents, that you can pay, a pretty reasonable service fee, and they'll pay that fee for you. So there's, ways to handle it. There's also, in terms of the visa appointment availability, sometimes you'll have to just book an appointment, even if it's not where you want to go in Mexico. Usually folks want to go to Mexico City. But sometimes you have to book an appointment, even if it's not a location in Mexico that you want to go to, and not a date that you want to have, and then request an emergency or expedited appointment. And then with that, you can request, the location that you want to go to and the date. And they've been granting them pretty freely, which has been wonderful. But yeah, it's just some working parts there that have to be handled. But yeah, Mexico has really been the main place.
Noah, we appear to be in green card season right now. The green card lottery is open. Do you have any advice for anyone who's applying for green cards in this current environment?
Yeah, well, firstly, in terms of the diversity visa program, the green card lottery, I can mention a few things about that. So firstly, enter. Lots of times I'll speak to Aussies about it, and they'll say, "Oh, it's a lottery, though. I mean, what are the chances?" And I say, "No, people do get selected. Um, Oftentimes I'll then get asked, "What is the exact percentage chance?" And it's as far as I'm aware, it's essentially impossible to figure that out because of how the program's structured, and it's per country, there's certain amounts, and then it's very complicated. But the bottom line is, it's worth entering. If the individual is married, then they can enter, and their spouse can enter as well. So you kind of have two shots at it. Another thing that I would mention is that I would recommend using just the regular official government entry site. You might be aware that there are a lot of pay sites. I think some of them probably might be scams. I don't know. That definitely would have to be careful about it. If you're doing that, but in my opinion, it's best to just use the official government site, just go straight to it. And it's pretty easy to use, pretty quick. Thirdly, you got to get it in time. So the entry period is open now, open on October 7th, and it closes on November 10th. So don't wait until, the last minute, get those entries in. If you're married, do one for your spouse as well.
No, repatriation is a big issue at the moment. There are a lot of Australians who have repatriated. In fact, we just completed a survey of 392 who have. And there are those that are thinking about it. Many of those are on green cards. Some of them are looking at a permanent move back to Australia, but others are looking to move back to Australia and then come back to the US at a later date. Now, to maintain your green card, when you're overseas, there are some issues that you need to be aware of. Perhaps you could just explain what it is required to maintain your green card if you're heading outside the United States for, say, 3, 6, 12 months.
So the first thing is, if you're a green card holder and you're leaving the US and you're not sure when you're going to come back, you think you may be out for an extended period, I would highly recommend that you apply for a re-entry permit. So a re-entry permit is normally issued for 2 years, and you can actually extend them as well after that. And that will help prevent the risks that when you come back after extended absence, that the Customs and Border Protection officer at the airport will say, "Yeah, hey, well, you've been gone, quite a long time. I don't really buy that you're still living here, and so, I'm going to take your green card away." Now, it's not quite as simple as that. And maybe if I can just say a little bit about that, because there's a lot of misconceptions about that. What can occur, if they get questioned, the green card will get questioned. So the officer would normally give them two options. First they would question them about it and this and that, and give the individual opportunity to make their case. And hopefully the person has kept up good ties to the U.S., and that definitely helps. Driver's license. Aussies that are putting off getting that U.S. driver's license and hold a green card, get your U.S. driver's license. It's worth it because they see that as a big thing. Filing U.S. taxes as a resident, having U.S. bank accounts if you still have employment, so on and so forth. But anyway, we'll give them a chance. And then if the officer really decides, look, I really don't buy this person is still residing here and therefore entitled to keep the green card, they'll give them two options. They can either voluntarily relinquish their green card through signing what's called an I-407 or appear before an immigration judge. Now, usually, I don't know the data, but I think oftentimes when folks are faced with those two options, they get scared of the idea of appearing before an immigration judge, and they'll voluntarily relinquish it. I don't want to say that's a mistake, but you have to be strategic about it. but I will say that your chances of keeping the green card are, or at least you still have a shot at keeping the green card if you agree to appear before the immigration judge. And it's not the end of the world. It's not like you're going to get treated as a criminal or anything like that. It just means that you're going to be given the opportunity to make your case, in front of the immigration judge when your date comes up, which is usually not for a couple of years because of the great backlogs. And during that time, while you're waiting for that, you get to keep the green card. So I think it's important for people to know that. Obviously, we always tell clients that in this scenario, because I think oftentimes folks get scared off by the immigration judge thing and just take that. So the first thing, like we said, get the reentry permit. Second thing, we've already spoken about keeping up those ties. There's driver's license, the bank accounts. If you own property, great. Somebody happens to have family here, employment, and so you're prepared to address it if the officer brings it up. Now, another thing is try not to be out for too long at one shot. But because that's how the officers, that's the main thing they look at, for this most recent departure, how long were you out? But, I have to strongly caveat that because oftentimes, I'll be speaking with clients and they'll say, oh, so I only have to come in every 6 months, right? And no, that's not correct. Really the determination that the officer's making comes down to, is this person still living in the US? And if they're just coming in every 6 months for a week, the officer may very well say, no, I don't buy that you're really living here still. It's not necessarily enough. It's just one, it's looking at the totality, the circumstances, and this is just one factor. Also to get the citizenship, which we were speaking about, earlier in this interview. If an individual is eligible for citizenship and they're about to leave the US for an extended period, might very well want to consider getting that US passport, because then you're all set.
Now, I know there's been some talk about tightening up the language about what is a specialty occupation under the E3. For example, I know if you're a lawyer, you need a law degree. If you're a doctor, you need a medical degree. But certain occupations such as manager or some of the other roles, say in marketing and advertising, can be performed by more than one bachelor's degree. Now, I know that this is complicated and that, for example, a lot of people have, rather than looking to a consulate, they've gone the route of the I-129 to renew their visa here, but those are adjudicated by USCIS folk who adjudicate the H-1B. And if you don't have a specialty visa, there's a high probability that in 6 months from now, you could get a letter saying that your visa has been denied because you don't have a specialty degree for that occupation. So I know that there is more, I know we were talking about it earlier, that there's talk of this being tightened up for the E3. Can you speak a little bit to that?
Even though the proposed change applies only to H-1B, the concern would be that it would trickle down to E3 as well, as we have seen, occur sometimes in the past. And it's complicated, what they're trying to do, but in short, the change would mean that it's no longer enough to show that the bachelor's degree, the role requires at least a bachelor's degree. If the changes go through, it will be necessary to show that the role requires a bachelor's degree in a specific field. And that could, really make it a lot harder for some occupations. Like you say, for a lawyer, it's very straightforward. Requires a very specific degree, a Juris Doctor degree, degree in law. For an architect, similar. For an engineer, you might think that it would be straightforward, but here's maybe a good example to illustrate. There was a court case earlier this year where USCIS had denied an H-1B to a mechanical engineer, believe it or not, because the officer argued that a mechanical engineer, there's a number of degrees in a number of fields that would be sufficient to be a mechanical engineer, and I know it sounds crazy, but that's what the officer argued and denied the case on those grounds. Fortunately, the federal court overturned it, and we were actually using that as precedent when we got challenged, with an H-1B on this point. But the government now wants to make this change and embed it into the regulations, saying it requires this degree in a specific field. And it's not as if you can just, because you might think, oh well, we'll just argue that the employer, they require this degree in this specific field. So there's two problems with that potentially. The first is the government doesn't necessarily care what the employer requires. They care about what's generally required in that occupation, and they'll look at their own, materials. So if there's U.S. Department of Labor materials that say that, a mechanical engineer, a number of degrees in a number of fields can work and be acceptable, then they'll key in on that, and say, well, yeah, I don't care. You think you require, you're saying you only require this, but we see, that for this occupation, it's not like that across the board. The other issue is oftentimes with H-1Bs and E-3s, you will have a situation where the applicant has a degree in a field that's not perfectly related to the occupation. And so then what you're kind of forced to do is argue in the case, that, a number of degrees can be accepted for it. Because if you don't, then they'll say, well, your guy or gal doesn't have the degree that you say is normally required. So it really will probably make things, a lot tougher, if this goes through. And then, I can say chances are good that it'll trickle down to E3.
No, I know there were some proposed changes to fee structures for different applications. I know that there was going to be a pretty significant hike in the citizenship fee. What has happened in that front?
USCIS, U.S. Citizenship and Immigration Services, proposed pretty much across the board fee increases. They were met with a lot of resistance, and they got sued. And that has kind of been, just not to take too much of a tangent, but in my opinion, a silver lining with all of these many changes that are happening, kind of all this crackdown on immigration, including legal immigration, is the courts. They really have been our saving grace. And, it's just been, in my opinion, I guess as a lawyer, wonderful to see, our government operating, correctly as it was set up as a government of checks and balances. The court system, keeping the other, branches of government, in check. We saw that with this fee increase. The USCIS was sued, and the case is still in process, but the judge issued a preliminary injunction, which means that these fee increases are paused. So, to your point, if somebody's eligible for naturalization, and we can talk about the requirements for naturalization if you want to, if somebody's eligible, now's the time to apply, before the fee increases by, I believe, close to 50%. Also, for individuals that are considering a spousal green card, now is a good time to apply before this, injunction is lifted or, things potentially change with the fees, because with a spousal green card application, there are a number of different fees, at play. But in short, if the fee changes go through, you're looking at an increase of around $1,000 to the total fees. So now would be the time to apply, to save that money.
Probably a challenge that may be facing some Australians on E3s is that the USCIS has lifted the minimum wage. Can you talk a little bit to that? Because it seems to be a pretty significant hike. And for those people on E3s who are sort of on the lower side of the Department of Labor scale, that might be a concern for them. And how would that affect them?
This is one of the more challenging changes, that's going on right now. And also just one of the just crazier, kind of changes because it happened suddenly. Normally when the government wants to make changes like this, they have to go through a whole formal rulemaking process, including a notice period, of at least 60 days, allowing for comments from the public, on the proposed, rule change and so forth. This one was done through this special interim final rule process, this, streamlined process, and it was just sudden. It was just, boom, and announced, yeah, we're increasing all these prevailing wages. What is a prevailing wage? So it's a fancy term, but it really just means the market rate for that, occupation and in that location where they're working. There's 4 different levels, at least in the Department of Labor wage data. And what they did is, whereas with level 1, they were looking at, I think it was the 17th percentile and saying, okay, level 1 wages are at, folks that are at the 17th percentile, we're going to increase that, by around 30%, to, I don't know, it's like 40 something percentile. And so on and so forth with the level 2 wage, level 3, level 4, everything, all the levels, they just kind of put them up 30%. So, but there's no, it begs so many questions, right? So how do we handle this? Well, first thing I'll say is we're hoping for an injunction. Like we were talking before about the beauty of our court systems and the checks and balances, we're hoping for an injunction. And it's very possible, so there is some hope there, okay? But at least for now, what we have to do is look at it on a case-by-case basis, see if there's an issue, and it only applies to new filings, because we're getting that question from clients. Okay, so, from corporate clients. Okay, so now do we have to, go through all of our, records for all of our current E3 or H1B or H1B1, employees and see if they meet the new, no, it's only for new filings. But yeah, with these new filings, we have to look at it on a case-by-case basis, see if there's an issue. If there is, sometimes we can check to see occupational classification wasn't correct before, and with a different, more accurate occupational classification, they can meet the prevailing wage. Also with the levels, maybe the level wasn't correct, we were looking at before like that. More often than not, though, what we have to do is actually look at private wage data, because you don't have to use the Department of Labor data. It's oftentimes the easiest, to use and the safest to use, but you don't have to. So that would probably be my key, takeaway point there in terms of how to handle it from a practical perspective is look at private wage data. Now, there's very specific requirements with the private wage in terms of what private wage data and surveys are acceptable. But that's really, what you usually have to do, when you have an issue.
What I'm understanding what you're saying is that anyone who has an existing E3, this doesn't affect them. But if someone who is applying for a new E3, either through a new employer or an E3 renewal of their existing E3, this will impact them. So therefore, what they should be doing is checking their current wage against these new wage structure that the Department of Labor is putting out, the prevailing wage. Because if they are below the prevailing wage, I'm understanding that would affect their ability to reapply for the visa if they're not being paid enough money that the Department of Labor is setting down.
That's right. That's right. Yeah. And so, you might have, a lot of, Aussie E3 visa holders where they were handling it, pretty much on their own, the application. And I know that, there's a lot of, Aussies that do that, and that's fine. But you may have, a good number where they / the company, needs to start looking at, having an immigration lawyer help, because it's just gotten a lot more complicated, in that regard.
Yeah, one of the theme that's been running through these videos that we've been recording is that the DIY E3 might have existed in 2019, but in 2020, unless you're working with an immigration attorney, at least getting guidance, then you can be making irreparable mistakes. And if you were, say, to travel to Mexico, you're fine, you've got your flights sorted out, you get there, you've dealt with all the nuances, and then you get there and find out that your LCA, the prevailing wage on your LCA, doesn't meet the guidelines, you can be denied a visa, which would then mean that would create a whole lot of issues. You're being denied a visa, which is not a good thing. And that probably would also prevent you from returning back to the US, would it not?
That's right. That's
So,
right.
yeah. So when we talk about speaking to an immigration attorney, we're not just saying that for the sake of saying it. These are the types of issues that you need to make sure before you get on a plane to renew an E3 or get a new E3 visa.
Yeah, yeah, absolutely. I mean, there's also the corporate compliance side, that a lot of gets lost, I think, in the mix a lot because, there are, certain things that the company needs to be doing with its E3 visa holders, and so sometimes that gets lost in the mix, with the DIY, approach also.
Noah, thank you for your time this afternoon. This has been very helpful. I'm sure there's, with these types of videos, there are people out there that are shaking their head thinking, wow, thank you. And there's probably others out there that are in a cold sweat right now. So apologies to those folks, but the goal of this is to provide you with the best information from experts. So as I say, apologies to those folks. But now, if someone wanted to contact you, what would be the best way for them to do that?
They can either email us at info@klugfirm.com or call us at 212-495-9245.
Noah, thank you for your time this afternoon. We'll actually include that information in the comments below.
My pleasure, James. Thank you for all that you do for Australians, in New York and throughout the United States. I love the Australian community. Tell all of our clients about it. It's a terrific organization.
Thank you, Noah. Take care.
Thank you. You too.